Companies could soon be penalised for severe discrimination at workplaces as part of new legislation tabled in Parliament. The Workplace Legislation Bill was first mooted in 2021 and will cover all employment decisions from hiring to dismissals. Under the proposed laws, firms cannot discriminate workers on 5 types of characteristics, and these include their age, nationality and sex. Authorities say these make up more than 95% of complaints today. And as for the remaining cases, existing guidelines on anti-discrimination will continue to apply. Those who don't comply will face penalties based on the severity of the cases. For example, if a firm indicates gender preference for certain roles in a job advertisement, the Manpower Ministry can issue directions or provide workshops and resources to correct stereotypes. If these breaches still are not rectified, the ministry can also impose thousands of dollars in fines. Firms can also be taken to court for more severe cases like intentional discrimination and unfair dismissal after an employee files a complaint. Still, MOM says it is focusing on education first to change mindsets and maintain workplace harmony.
We are heartened to see that existing protections in the Tripartite Guidelines for Fair and Progressive Employment Practices will be enhanced in law, so that workers can be assured of stronger levers to deter discriminatory practices. And at the same time, also allow them to continue access to individual recourse, including monetary compensation. But having said that, the legislation is not the panacea, and more needs to be done to achieve our vision of fairer workplaces.
Still, there are some exemptions, like if a firm has a genuine business need. For instance, a wellness centre with a mostly female clientele can indicate preference for female therapists, but they will need to provide that explanation to authorities if a complaint is raised. Prioritising the hiring of locals, seniors and persons with disabilities will not be considered under this bill. Religious groups will also be allowed to indicate their preference for hiring someone from the same faith. For now, small and medium enterprises with less than 25 employees are exempt, as they may not have the operational capability to comply. This will be reviewed 5 years after the legislation takes effect.
They will probably need a bit more time to prepare for the law, especially in areas like strengthening the recruitment practices or needing to implement the grievance handling process. It's actually better for perhaps the bigger companies to take the lead on this. Many of them already have some form of established processes. So once the industry has somehow adjusted to the new law, then I think the SME owners, the employers, can have some reference.
A second bill will also be introduced next year. It will cover the rights and processes for private claims. The workplace fairness legislation will be implemented by 2026 or 2027. And for a closer look at this issue, we speak next to Dr. Matthew Matthews, Head of Social Lab and Principal Research Fellow at the Institute of Policy Studies at NUS. Welcome to the show, Dr. Matthews. More action against discrimination at the workplace, but penalties are based on the severity of breach. How effective are they in tackling discrimination cases?
Well, they certainly can be effective. Penalties do deter organizations from engaging in discriminatory behavior, since it gives them a clear understanding of the consequence. You've got some kind of discrimination can lead to certain types of consequence. Perhaps it could be fines for the company. And that will certainly keep companies conscious about the fact that there are some actions which they need to steer clear from. And there's also, of course, a continuum of severity. So even when there are unintentional violations that do actually hurt people, then there are also some penalties. So overall, the picture is that things need to be done. But if you rely only on penalties, that may not create the kind of behavior change we want. We need a broader strategy as well that includes training, deeper cultural change. With all that together, you will be able to sustain some kind of behavior change.
And to see this change, the law is setting out 5 characteristics for safeguarding, which include age, nationality, and gender. And apparently they make up more than 95% of complaints today, according to authorities. Is coverage of the bill extensive enough?
I mean, the fact that 95% of the discrimination complaints that are received by agencies fall under these 5 protected characteristics does say that you can actually, with this law, deal with the great majority of these situations. I think that's good. But there's always going to be some areas where people feel that you need to make a firm stance against discrimination, areas such as sexual orientation, for instance. But it makes sense to start somewhere, and it's probably best to start with those where it's very, very clear that they are the areas where the most complaints come from.
There are exemptions. For now, firms with less than 25 staff are exempt, but this will be reviewed after 5 years. What do you make of this? Is the period of 5 years too long?
Well, hopefully there'll be interest to review this even sooner. But it's true that for companies to follow the expectation of any legislation on fair workplace practices, there is a burden of compliance measures. And this will be hard if you don't have the kind of size and dedicated types of human resource and other management personnel to be able to take care of these policies well. Nevertheless, we should hope that even small companies would make special effort to be trained to put in some of these policies to make their space a lot more inclusive, even without the burden of legislation.
And hiring and firing is by and large an employer's prerogative. Earlier you were talking about, why it needs to go beyond the penalties. Can legislation really make the difference here? Well,
it's true that legislation makes some amount of difference. You definitely, as an employer, you can make a decision to hire or fire. But ultimately, if that hiring and firing is stemmed from some kind of discriminatory principles or stereotypes about particular groups, or believes that some groups are not performing as well because of some kind of prejudices, then really legislation should signal to these employers there's some lines that they should not cross when they hire and fire, and certainly it should pertain to some of these protected characteristics.
We heard earlier, Dr. Matthews, from SNEF that companies probably need more time to prepare for the new law, and that bigger companies are encouraged to take the lead here. What would an ideal grievance handling mechanism within a company need to look like in your view?
Well, one, it really has to be clear grievance handling mechanisms. So you're not guessing in terms of who you need to speak to, who you need to make the report to. There should also be good structures to make sure that confidentiality is preserved. So you don't have to fear that after you have made that complaint, your identity may be revealed, you may be subject to some kind of reprisals. There also should be that sense of fairness and accountability. We should know that I've put out a complaint. There are clear sets of measures. There's committees or groups or investigations that will happen. And if someone is something has been done wrong, then that person will be taken to task and there is some kind of clear penalty. All that needs to be clear to people. I think that will help people to feel a bit more confident.
So it's a lot about trust.
Handling mechanisms.
It's a lot about trust, right, Dr. Matthews? How much can the law achieve if trust is broken between management and the staff?
Well, maybe that's why you probably need legal frameworks, because sometimes even when there is some kind of compromise, or rather the relationship of trust is broken between employees, they still have, and management, they still have recourse. They can look to legislation, they can look to some kind of tribunal outside their corporations to be able to deal with that. So legal frameworks do set the kinds of principles, the baseline of what is considered acceptable. But at the same token, we have to realize that if there is no trust, then people will always be second guessing what management may be interested in doing, whether there's going to be retaliation if they put out a complaint, and that might make the place not as inclusive as it should be.
All right, Dr. Matthews, appreciate your insights as always. Dr. Matthew Matthews there from IPS.